Hello everyone! I'm pleased to introduce you to the OHRC's updated Policy on Preventing Discrimination because of Pregnancy and Breastfeeding. I'll give you an overview of the key parts of the policy, and we'll have time at the end for questions and answers. The policy is based on the Ontario Human Rights Code, and it begins by setting out the foundations of the code. The code is the law that provides for equal rights and opportunities and freedom from discrimination in Ontario. The Code recognizes the dignity and worth of every person and aims for a climate of understanding and mutual respect so that each person feels part of the community and is able to contribute to the community. Under the Code, it is against the law to discriminate against or harass someone because of their sex, including women who are pregnant or breastfeeding. Most human rights claims based on discrimination because of pregnancy relate to employment, but they can also relate to housing, goods, services, and facilities, contracts, and membership in unions, trade, and professional associations. The policy sets out some principles that apply to pregnancy and breastfeeding. Having children benefits society as a whole. Women should not be disadvantaged in society because they are or they have been pregnant. The Supreme Court of Canada recognized that the financial and social burdens and cost associated with having children should not rest entirely on women. While women have made major advances in gender equality, discrimination against women because of pregnancy continues to be common in society, particularly at work. The policy recognizes that discriminating because of pregnancy is sex discrimination, and that women face unique experiences of discrimination because of their ability to become pregnant. The policy also applies to trans people and people of diverse genders who are pregnant or nursing and who may not identify as women. The policy defines pregnancy broadly. Discrimination based on pregnancy can happen when a woman is trying to get pregnant, was pregnant or states she intends to have a child, will be taking a maternity leave, has an abortion or experiences complications related to an abortion, or has a miscarriage or stillbirth or experiences complications related to a miscarriage or stillbirth. Discrimination can also happen because a woman experiences complications related to pregnancy or childbirth, lacks energy due to pregnancy, is perceived to be too big or fat while pregnant or is unable to wear a form-fitting uniform, is recovering from childbirth, receiving fertility treatments, or is breastfeeding. The policy recognizes that a woman's experience of discrimination because of pregnancy may be unique based on other aspects of her identity involving other code grounds. For example, there are distinct negative stereotypes about pregnant women who are parenting on their own, are young, have a disability, receive social assistance, are racialized or aboriginal, or are lesbian or bisexual. Discrimination because of pregnancy may overlap with discrimination based on family status. For example, a new mother in the immediate postnatal period is protected from discrimination because of pregnancy and family status. Men may also face family status discrimination because of their relationship with women who are pregnant, or because they have accommodation needs relating to caring for a newborn. Trans persons or people of diverse genders who are pregnant or nursing a baby may be vulnerable to unwanted attention, disrespectful treatment, or inappropriate actions or comments because they're seen as not conforming to gender norms. The policy also recognizes that pregnancy can intersect with gender-based violence. The policy deals with different types of discrimination because of pregnancy and breastfeeding. Let me go through some of these with you. Discrimination may be direct and overt, where a person or organization deliberately treats a woman negatively because she is, was, or may become pregnant. For example, a breastfeeding mother is asked to stop breastfeeding her child or leave a restaurant. Or an employer dismisses a pregnant employee because of stereotypes that pregnant women can't do their jobs. Discrimination may also be indirect, where it is carried out through another person or organization. It's often subtle, so you may need to look at all the circumstances of a situation to see a pattern of behavior. Sometimes discrimination is more complex and systemic. it can be embedded in the patterns of behavior, policies, and practices that are part of the structure or informal culture of an organization or sector. For a woman who is, has been, or may become pregnant, systemic discrimination can appear to be neutral, but in fact, it creates or perpetuates a position of disadvantage by limiting her rights and opportunities because of her pregnancy. For example, a government employer has a policy that after 3 years of continuous service, a contract employee becomes a permanent employee. However, the policy excludes unpaid leaves of greater than 60 days, including maternity and parental leaves. While this policy appears to be neutral, it has an adverse effect on women who, more often than men, have gaps in their employment for maternity and parental leaves. The Code also protects people if they experience reprisal or threats of reprisal. A reprisal is an action or threat that is intended as retaliation, punishment, or payback for claiming or enforcing a right under the Code. Discrimination includes harassment, which can happen at work, in housing, or in services. Pregnant or breastfeeding women are harassed when they experience a course of vexatious comment or conduct that is known or ought reasonably to be known to be unwelcome. Vexatious means distressing or annoying. Harassment includes repeated negative comments about a pregnant woman's appearance, her pregnancy symptoms, or whether or not she's a good mother. It includes repeated unwanted touching of a pregnant woman's stomach, and negative comments about whether a pregnant woman can do her job. Harassment may not explicitly refer to a woman's pregnancy. An example might be a pregnant woman who experiences groundless and repeated criticism of her work, or becomes the brunt of demeaning teasing that it's not directed at other employees. Widespread or ongoing harassment can lead to a poisoned environment for pregnant women. Or, in some situations, a single statement or incident can be bad enough to create a poisoned environment. Generally, a poisoned environment is based on the nature of the comments or conduct and the impact on an individual or group, rather than just on the number of times the behavior happens. Not addressing harassment and discrimination could cause a poisoned environment. Employers, landlords, and service providers have an obligation to maintain an environment that is free of discrimination and harassment, whether or not anyone objects. The Code says that employers and unions, housing and service providers have a legal duty to accommodate the needs of women because of pregnancy, unless it would cause undue hardship. Accommodation means changing policies, practices, rules, or standards so pregnant women can have equal opportunities at work, in services, or in housing. The policy lays out 3 principles that guide the duty to accommodate. 1. Respect for dignity. 2. Individualization. And 3. Integration and full participation. The policy discusses how each of these principles applies to accommodating pregnant and breastfeeding women. When accommodation meets these 3 principles, it's considered appropriate accommodation. The policy also looks at the importance of designing society with the needs of pregnant women in mind, and removing existing barriers. Good inclusive design will decrease the need for people to ask for individual accommodation. Here's an example of an inclusive design. A large retail outlet designs its facilities to include a nursing room with comfortable chairs for women to breastfeed their children in private. It also creates a breastfeeding policy and educates staff on women's rights to breastfeed their children throughout the store. Where an accommodation will cause undue hardship, the organization has to put the next best solution in place, such as interim accommodation, while appropriate accommodation is being phased in. The policy goes through the accommodation process. The accommodation process is just as important as the accommodation that's provided. Accommodation is a multi-party process, so everyone needs to cooperate. The policy talks about the responsibilities of the woman requesting accommodation and the responsibilities of the accommodation provider. If you need accommodation based on pregnancy, you're responsible for making your needs known. This includes cooperating during the process and providing any necessary documentation outlining your limitations or your needs. However, you don't need to give documentation on the needs that are associated with the natural progression of your pregnancy. For example, your need for doctor's appointments or the need to breastfeed. The policy sets out what organizations must do throughout the accommodation process. For example, they must accept a woman's accommodation request in good faith, unless there are legitimate reasons for acting otherwise. They must take an active role throughout the process, and they must get expert advice where it's needed. In many cases, it will not cost a lot to accommodate somebody's pregnancy or breastfeeding needs. Accommodation may simply mean making policies, rules, and requirements more flexible. Some examples are flexible work hours, relocating someone temporarily to another location, workstation or assigning alternative duties, chairs to sit at work or in a service environment, breaks at work as needed, a quiet place to rest during breaks, time and space to breastfeed or express and store milk, or allowing a mother to bring a baby to work or school to breastfeed. Accommodation does not need to be provided if it causes undue hardship, which is a very high standard. The Code lays out only 3 factors that can be considered undue hardship. They are cost. The cost to the organization to make the accommodation must be so high that it affects the viability of the organization, such as making it go out of business. Outside sources of funding, if any. These could help to offset costs. And health and safety risks. If an accommodation causes significant health and safety risks, this may create undue hardship. There are no other considerations laid out in the Code, not business inconvenience, employee morale, or customer preference. An organization would need to use objective information to show that an accommodation would cause undue hardship. The policy explains the special protections that women have through the Employment Standards Act and the benefits under the Employment Insurance Act. It states that unions and collective agreements must comply with human rights laws. The policy explains that women are entitled to the same rights to health and disability benefits given to other employees who are covered for health-related absences. The policy describes the type of discrimination that women could experience in the workplace because they're pregnant. For example, at a job interview, except in specific circumstances, employers cannot ask a woman if she is pregnant, has a family, or plans to become pregnant. An employer can't refuse to hire a pregnant woman for pregnancy-related reasons, such as thinking that she's going to be going on maternity leave, or that it will be inconvenient or to train a replacement soon after a woman who is pregnant is hired. Employers cannot withhold or withdraw projects or opportunities from pregnant women or women of childbearing age because they question her commitment, competence, or capacity, or because they believe that she'll be gone on leave soon anyway. If the employer notices a change in a woman's work performance that's related to her pregnancy, for example, she's not as productive because she tires more easily, they should ask about this relationship. In these situations, employers must explore accommodation options before disciplining a woman or terminating her employment. If terminating a woman's job is in any way based on her pregnancy or maternity leave, this will violate her rights under the Code. Good human resources practices such as documenting performance problems and progressive discipline can help an employer show that a pregnant woman's employment was terminated for reasons that were not related to her pregnancy. Discrimination based on pregnancy or having a young child is illegal in housing. Sometimes a woman who is expecting a child may be refused a rental application by a landlord who says it's because the apartment is not childproof. Or a landlord might discourage or deny applications from families that are expecting children by saying things like, "It's a quiet building," "It's an adult lifestyle building," "The housing is not soundproof," or "The apartment is geared to young professionals." Landlords must address any possible discrimination or harassment relating to pregnancy within their rental housing environment, involving tenants, a landlord's agent, or others working in the housing environment, such as maintenance workers. Services include colleges and universities, hospitals, health services, insurance providers, malls, parks, public transit, stores, and restaurants, among others. Breastfeeding women cannot be told to cover up, be more discreet, or move elsewhere, even if someone complains. Service providers should design their services to include pregnant and breastfeeding women. For example, both the City of Toronto and the City of Hamilton have policies that support breastfeeding in spaces controlled by the city. People who believe they have been discriminated against based on their pregnancy or because they're breastfeeding should try to raise the matter or make a complaint with their employer, union or other vocational association, landlord, or service provider. If this is not possible or the problem is not addressed, they can ask the Human Rights Legal Support Centre for advice or make a formal complaint, called an application, directly to the Human Rights Tribunal of Ontario within 1 year from the last alleged incident. Parties at the tribunal can ask an adjudicator to consider this policy when making their decision. People can also ask another person or organization to file an application on their behalf. The policy concludes with a section on the organization's legal duty and responsibility to maintain an environment free from discrimination and harassment because of sex. Organizations must take steps to prevent and respond to violations of the code. If they don't, they may be liable and face monetary penalties or other orders from a tribunal or court. It is not acceptable to be unaware, to ignore, or fail to address potential or actual human rights violations, whether or not a complaint is made. The policy lays out several steps organizations can take to make sure they are following the code, including creating complaints procedures, doing education and training, and creating accommodation policies.